All right, good morning, everyone, and thank you for being here. We'll just give everyone a moment to settle in. All right, I think we'll get started here. So everyone, welcome to the 29th installation of the Panich Training Academy. Today we'll be discussing AI, particularly navigating the frontiers and kind of setting guidelines and instructions and best practices on how to interact with it in IP. So I'm Sean Douglas. I'm an associate patent attorney here at Panich and Swarzy, and I'll let my other two co-presenters introduce themselves. So Steve.
Hi, thanks, Sean. My name's Steve Lustig. I am an attorney who specializes in trademarks and copyrights, so soft IP. I like to tell people I'm a trademark junkie. I love trademarks. I love working on trademarks, and I do everything with them: prosecution, getting registrations, enforcement, online enforcement. If you have a trademark issue, I can probably deal with it, or I can deal with it. Let's put it that way. Ikenna?
Thanks, Steve. Yes, my name is Ikenna. Hello, everyone. Good morning. I am a patent attorney at Panich Swartz Belsario Nadal. My background is in biology and pharmaceuticals. My practice focuses mainly on assisting inventors with patent prosecution and litigation. So with that being said, I'm looking forward to a great session today. Just a reminder that this session is being recorded and will be available on our website by tomorrow afternoon. Please feel free to ask any questions in our chat or Q&A. We'll be keeping an eye on those. And for those seeking CLE credits in Delaware, Georgia, Pennsylvania, or Virginia, please make sure to stay for the entire session, respond to the two pop-up polls, and fill out the feedback survey at the end.
All right. With that, we'll get started into the presentation here. All right, so this is just a little session overview of kind of what we plan on doing, introduction, and then I'll start with kind of what we mean when we say AI. I kind of want to give a little bit of a background on kind of how we train and create these models and what they do to set up a nice background for the rest of the presentation. And then Steve will go into the interplay between AI and trademarks. Ken and I will go through the interplay of AI and patents, and then we'll finish up with the interplay of AI and copyrights. So again, like I said, what do we mean when we say artificial intelligence? So this right here is just a brief definition that I found that came from the actual godfather of artificial intelligence back in 1954. It is the science and engineering of making intelligent machines, especially intelligent computer programs. It is related to the similar task of using computers to understand human intelligence, but AI does not have to confine itself to methods that are biologically observable. Again, one of the big things that I want to get across in this intro is how not new AI actually is. This definition was created in 1954, and AI kind of kicked off back then in earnest in 1954. But that said, the concept of AI goes way back. You can go all the way back to the 17th century when you can start seeing the first links between reasoning and mathematics. You can go to the 19th century, 1837, Charles Babbage creates the first analytical computer, to Ada Lovelace, who writes the first computer program in 1843. And then you can kind of get into more of the commonly known things like Alan Turing, the Turing test, asking, can a machine be as smart as a human, or can a human tell a difference between a machine and a human, I should more accurately say. And then the actual term of artificial intelligence was introduced in 1956, like I said. And then going through here, you can just kind of see some more of the progression. And then when you get to 1997, this is when we start kind of seeing what we probably in modern days think of artificial intelligence when you hear it out loud. In 1997, when famously IBM's Deeper Blue beat Garry Kasparov in chess. Looking forward up to 2011, you start seeing the introduction of your smart assistants, your Siri, your Alexa, et cetera. Also, that's when Watson wins Jeopardy, again, IBM. And I will give a little bit of qualification. I am a former IBMer. I was in-house patent counsel at IBM for many years, so some of my references are pretty IBM heavy sometimes, so my apologies for that. That all said, so what I find when I talk about artificial intelligence to a lot of people is there's a conflation between three main terms. It's AI, artificial intelligence, ML, machine learning, and deep learning or neural networks. Most people kind of interchange them, thinking that they mean the same thing or similar. But in reality, artificial intelligence is kind of the big circle umbrella. Machine learning is within that, and then even deeper within that is deep learning. So the basic kind of artificial intelligence that we understand is called reactive intelligence. It's basically programmed to provide a predictable output based on the input it receives. So in this sense, you can kind of think of it like your normal call when you call into a bank or you call into something and it says press 1 for a language and you press 1, 2, or 3 and it brings you into that language. Or it then from that screen it says, do you want to make a talk? You press certain numbers and they're pre-programmed to give you a certain result. So that is the most basic kind of AI. And that, again, is called reactive artificial intelligence. Then the next two types are machine learning and deep learning. And this slide will go into a little bit of a difference between the two of them. So machine learning is essentially requires human input. It determines the hierarchy, the human determines the hierarchy of features in hand-coded decisions. So essentially a human is gathering all the data that's going to be input into the model itself and is it's rearranging it and organizing that data into certain subgroups. So there's some type of human input and involvement before the training of the model begins. And because we're doing that, machine learning models can actually use smaller data sets than the deeper learning neural networks. So kind of more common instances of machine learning as we know it are Spotify, Netflix, and Amazon, where every like updates and reinforces their algorithm. Essentially, a human is encoding that data. So you're reinforcing the algorithm itself to learn over and over again what you like by actively providing feedback. Then we can go into the deep learning. And deep learning is, like I said, a subset of machine learning. Deep learning automates much of the feature extraction pieces of the process that we just went over. So it eliminates the manual human intervention that's required in machine learning. It enables the use of very large data sets because we're getting rid of that human coding and the feedback process. It means a lot of data, terabytes of data, in order to train a deep learning model. So for example, what we call deep learning models and neural networks, if you're creating one from scratch for your company, it's usually called another term that's thrown out is a foundational models. So you're training a deep learning algorithm on huge volumes of raw, unstructured, and unlabeled data. Like I said, terabytes of data are culled from the internet to input into the machine learning algorithm. Then it just improves through repetition through itself through multiple layers of algorithms. So here is kind of an illustration of what a deep neural network looks like. We have that input layer of the terabytes of data. It goes into the algorithm itself. It has multiple hidden levels of nodes. Essentially, what's happening there is the machine is vectorizing and assigning weights to everything. I won't go into too much of the specifics, but this is just kind of an overview of what the models are actually doing. So what we're doing is intaking a lot of data from the internet usually, or your company's data, or any data that you want to provide it. And then it is training itself on that data in order to get you a particular outcome that you want it to. So again, the most important takeaway that will come be a theme throughout this is that it is taking existing data out there and putting it into the model and learning on that. And we'll get more into why that's important as we go into the various IP sectors later. And then this is just kind of a brief overview illustration of what you do to create that model. Just a summary of what we did. You get the data. If it's machine learning, you go to step 2, you're going to clean and prepare that data and get it ready to be inserted into the algorithms themselves. If it's a deep learning model, you exclude step 2. Then it goes into the training method where you're going into and the algorithm is running itself and learning based on the weights and the vectorizations and all that stuff that's happening. Then you're testing the data. You'll give it a test. You'll say if it's an image classification model, you'll put in an image of a cat, and you'll see if the model can identify it as a cat or not. If not, that means more tuning or more data is most likely going to be needed. And that is the improvement step at the end, fine tuning that. If it needs more data and more time, then that's what you do at the end of it. So again, just a very quick, brief overview of what we mean about what AI means when we were talking about it to go in. Again, the biggest takeaway here again is just that ingestion of massive amounts of existing data. And with that, I will turn it over to Steve to talk about the interplay of these AI systems and trademarks.
Thanks, Sean. Hi, everybody. Thanks for advancing the slide too, Sean. So the way I always like to begin these things is with a foundation. So this may be a little bit too basic for people, but I always feel it's necessary to, or it's advantageous to get back to the basics. So what is a trademark? A trademark is a source identifier, and that's a fancy way of saying it's a brand name. Okay, this is the tool by which your consumers find you or in your products in the marketplace. So it distinguishes your products and services from the services and products of other people. And the way it works is, the example I always like to give is, I'm a Coke guy. I don't particularly care for Pepsi. I mean, I'll drink Diet Pepsi if I have to, but really I'm more of a Coca-Cola person. So when I go into the supermarket and I'm looking for Coca-Cola, I go into the aisle for beverages and I look for the can with the red motif and that says Coca-Cola on it. And I know that by looking at the can, that product was produced by, the company that I want to do business with, and I'm going to purchase that product. And it's not the same as the product in the blue can, which I'm not going to purchase. So that's really the way trademarks work. It's the ability, it gives consumers the ability to find what they're looking for in the marketplace quickly and efficiently. Now, trademark law is part of the law of unfair competition. What do I mean by that? Well, the easiest way to engage in unfair competition, well, I say one of the easiest ways to engage in unfair competition, is if you want to sell your product, let's say it's a beverage, and you want to move your product and sell it, but there's no traction for your product in the marketplace, it's very easy to copy the Coca-Cola or the Pepsi trademark, put it on your product, and pass your product off as the product of somebody else. Well, now the consumer's been unfairly defrauded, and you've made a sale that you weren't entitled to. So that's unfair competition, but that's where the law of trademark starts from. That's really kind of genesis here. Trademark is not a verb. I want to repeat that. Trademark is not a verb. When people say, I want to trademark that, and I'm in the room, it sounds like nails on a chalkboard to me. And the reason why is because it conflates a lot of things. Trademark is a thing. It's your source identifier. It's your brand. It's a noun. It is not something that you do. When somebody says, I want to trademark that, what they're usually doing is they're conflating the idea of the trademark itself and the process of protecting the trademark. So you can protect the trademark in the United States just by using the trademark. The trademark already gets protection under the law of unfair competition, but a lot of people go the extra step, and it's always advisable to go the extra step and protect your trademark by registering it. So if somebody is in let's say a meeting room with you and they say, I want to trademark that, they don't know what they're talking about, or at least they have a very unclear understanding of what the process is. So the next thing is the strength of trademarks. Some trademarks are easier to protect than others. So we start with fanciful trademarks. Those are like the Nike swoosh or the Apple with the bite out of it. Then there are arbitrary trademarks. That's like Apple for computers, totally arbitrary. Those are very strong trademarks. They're easily to protect. They're easily protectable because they don't really involve any mental pause to be able to, or they create a mental pause so that you don't have to think too much about it being a trademark. Suggestive trademarks are a bit weaker. Suggestive trademarks are like easy fit, easy glide, things that suggest something about the product. They're still protectable, but they're not as strong as fanciful or arbitrary marks. Then you get into merely descriptive terms. Merely descriptive terms are not protectable because they're part of the regular, language lexicon, unless they've acquired secondary meaning or acquired distinctiveness. I'll give you an example. I'm an auto racing fan. There is a track called the Indianapolis Motor Speedway. All right, the mark Indianapolis Motor Speedway is descriptive. It's a motor speedway. It's in Indianapolis. So it's merely a descriptive term. However, as many people know, they've been running the Indy 500 there for over 100 years. And through all of that time, the merely descriptive name Indianapolis Motor Speedway has acquired the distinctiveness or the secondary meaning to become a strong trademark. So that's what we talk about when we're talking about merely descriptive marks and them having acquired distinctiveness or secondary meaning. Finally, we get to generic or functional things. Generic terms like soap are not protectable. The person in the meeting room who says, I want to trademark that, if they stand up and they say, hey, I want to trademark soap, and that way nobody else can use the word soap, that's ridiculous. Okay. Generic terms can never be protected as trademarks. Functional things, let's say the wing on a car that creates downforce, can't be protected. It's functional. That's the functional stuff is the area of patent law. Generic stuff just can't be protected. Next slide, please. Thank you. Okay, so now we start talking about AI. If you are creating a trademark, and let's say it's a logo or something, and you create it using AI, which we'll get to in another slide, one thing you need to bear in mind is that creation does not start your rights. Okay, US jurisprudence is filled with cases where somebody is suing based upon the idea that I created that trademark first, therefore I have rights to it. That's very far from the case. In the US, trademark rights begin when the trademark is used. So Coca-Cola begins receiving trademark protection and they begin receiving protectable rights when they start using the trademark on the product in the marketplace, right? In many foreign countries, there is a first to register or first to file trademark system. In those countries, it is the first person to file for the trademark that gets the rights. But again, it's not first to invent the trademark, okay? It is very important to understand that the first person to invent it does not necessarily get the rights. They may get rights if they are also the first to use, but invention is not the touchstone here. It is priority of use. And in foreign countries, priority of filing and registration. Next slide, please. Thanks. So what happens when you use AI in the creation of trademarks? Well, you can create the trademark. Okay, you can find a trademark using AI, but then that's not the end of the road. So this is the beginning of the road. This is, asking ChatGPT or Logo AI to create a trademark. So as you'll see in the first example, I entered, give me a new trademark for use in connection with beer, and it came up with Brew Vibe. Okay, and it explained why it created that. With Logo AI, if you've ever used it, you say what industry you're looking to create the trademark in or the logo in, and then you enter a few things. And I entered in the literal portion, Zoom Zoom. Here's the problem. I may have created a trademark here, okay, or a logo. That doesn't mean that I have protectable rights in any of those. Okay, Brew Vibe could be infringing somebody else's earlier used trademark. Zoom Zoom, I know, because I'm a car person, is a trademark owned by the Mazda Corporation. Okay, so if I start using any of these logos down at the bottom, I could get in trouble because I could infringe the rights of a third party. So it's important to know that even though these tools are out there where you can use AI to create a logo or create a trademark, that's not the end of the road. You now need to go through the legal process of clearing that trademark and making sure it's available for use. Because remember, it's not first to invent, it's first to use. Next slide, please. Next slide, please. Great, thanks. So once you've created the trademark, you need to do a clearance search, or it's very highly recommended that you do a clearance search. The reason why you want to do a clearance search is because you want to avoid infringing the rights of another person. What is trademark infringement? Remember, a trademark is a source identifier. It's a tool to allow consumers to find what they're looking for in the marketplace and to not get confused between purchasing a bottle of Coke or a bottle of Pepsi. So the touchstone of trademark infringement is an infringing trademark is one that is likely to cause confusion, deception, or mistake about the source of the goods and services. Okay. And it's that likelihood of confusion in the consumer's mind that's trademark infringement. Okay. The goal of a clearance search is to avoid that likelihood of confusion. Okay. So even though you've created a trademark, it's important to do a clearance search and make sure that trademark does not infringe the rights of a third party by creating a likelihood of confusion, and you want to make sure it's okay to use. Now, there are different search tools that you use in clearance searches. The traditional one is just regular clearance searches, where in the United States, we search the federal trademark records, state trademark records, because remember, in the United States, we have a federal trademark registration system and also each state has their own trademark registration system. And then common law, which is, you search different sources to find out if there's anybody making unregistered use of a trademark. Because remember, under the law of unfair competition, somebody can have trademark protection for their logo or their mark without having a registration. Now, I want to turn to some industry-specific tools that are also very important in trademark searches. I'm going to isolate the industry of pharmaceuticals. Pharmaceuticals are very interesting because they're regulated the names are regulated both at the trademark level, but also at the FDA level. So you have to, if you're experienced in this area, you need to get approval of your trademark at the FDA, and you have to clear the trademark registration process at the U.S. Patent and Trademark Office. There are tools to help you do clearance searches in that space. One is the Phonetic and Orthographic Computer Analysis Tool, or POCA. That is available at the FDA website. Basically, you enter in your trademark, your proposed trademark, and it comes back with the closest matches. The rule of thumb at the FDA is if you pull a POCA score with another existing name, and the results are given in percentages. If the percentage is 70% or higher, there is a chance that the FDA will refuse your proposed name. So you're looking for POCA scores of lower than 70%. Then there's the Pharma in Use database. That's a database of, as you might imagine, names that are in use in connection with pharmaceuticals. Again, when we do clearance searches, particularly in the pharmaceutical space, we go the extra step of looking at these tools to help clear and to help make sure that your proposed mark is not infringing or likely to be confused with the mark of another party. Next slide, please. Thanks. Here's the first poll. So poll number 1, I'll give it a minute. You can populate the radio button. And I'll make this quick. When we do clearance searches, personally, I like to give clients options. I usually give three options for the level of clearance searches. First one is knockout, where you're just looking for exact matches. Some people just need that level of investigation. Is there an exact match out there? If there is, I'll choose another mark. Next one is preliminary. This is what we call an in-house search, where we look at the risks based on what we can do sitting at our desks. Finally, there's comprehensive. This is the holy grail of trademark searches. This is where we hire an outside vendor. We get reports. They're all computerized now, but in the old days, they looked like what you're looking at there with the pictures. And you can see, especially with the picture on the right, some search reports were thin, some were thick, but it's like Forrest Gump's mother used to say, it's like a box of chocolates. You never know what you're going to get. Next slide, please. Thanks. So you can do searches with AI tools, okay? But you kind of do that at your own peril. So there are tools, I've given 2 examples here, and you'll notice that there are caveats when you do these things. So for example, CoreSearch has a product called Trademark Now, and it'll actually help you generate a name. But I plugged in a name, and you'll see this caveat there. It says the score I pulled on that name is 1 out of 5 because it simultaneously looked to see if there were similar names out there, and based on their score, it said, "quote you definitely should consider changing your mark." So again, you can create a name using AI, but you still need to search it. And then the next step says again, you should do a name search. Questel's product is interesting because it presents another caveat. It says we don't provide any legal services. You need to get a legal expert to look at these results. Okay, so again, creating the trademark and doing a trademark search using the AI tools, it's possible, but you still need a trained attorney to help you kind of navigate the jungle. Next slide, please. Thanks. One of the things that comes up when you're doing these searches, these clearance searches, is there a congested market? So a congested market is one where, let's say you have the letter W. There are a billion W's out there. I don't know if any of you are baseball fans out there, but I presented 2 trademarks. For those of you with a trained eye, the trademark on the right is the Washington Nationals logo. The trademark on the left is the Walgreens logo. Obviously, the two are very, very similar, and they cover some similar stuff. Both the Washington Nationals and Walgreens sell, for example, food at retail, or they sell products, clothing products at retail. So if you are presented with a congested market for the proposed trademark that you've created through AI, you want to search to see if there's any differences. You want to look at differences between the marks themselves, differences between the goods and services, maybe sophisticated consumers, channels of trade, things like that. Again, these are the things you want to do to clear your trademark. Next slide, please. Thanks. Finally, I want to talk about when trademarks are used in connection with AI products. Okay, because you can have a trademark and you can trademark protection is available when you use that trademark in connection with a product. So again, I go back to the foundation. Trademark protection for Coca-Cola begins when you use the trademark in connection with the beverage. Okay, trademark protection for Hershey's begins when you begin using the trademark in connection with the chocolate bar. So here are a few examples of trademark of identifications of products or services for which you can use a trademark in the AI space. So the first one is household cleaning robots with artificial intelligence. Well, you think about it, that could be anything from a Roomba to a fully sentient vacuuming cyborg, okay? But that's what you're using your trademark in connection with. Humanoid robots with artificial intelligence for preparing beverages. Neat idea, but think about it. There were these cases out there you may have heard of involving Vanna White and the cast of Cheers, where Vanna White, somebody made a humanoid robot out of Vanna White, and somebody made a humanoid robot out of Cliff and Norm at Cheers, and there were lawsuits over it because the actors themselves had rights of publicity. So just because you can get a trademark that you can use in connection with this stuff doesn't mean that there are other peripheral intellectual property issues that you have to navigate. And then downloadable computer software, as you'll see, computer software can be anything. So you have to specify what your computer software is to the satisfaction of the trademark in order to get these IDs approved. Same thing with services, rental of humanoid robots, artificial intelligence as a service. You can have a trademark for any of these things. You just have to go through the proper process of using your trademark in connection with those things. And then I'll throw things back to Sean and Ikenna.
All right. Thank you, Steve. Yeah, so next we'll talk about kind of the interplay between AI and patents. Kind of like she did just at the top, basic foundation. I won't read this. I won't go into it. I think everyone here probably knows what a patent is at this point. So there it is for your convenience if you want to look it up. So one of the main issues that comes up when we talk about AI and patents is the concept of inventorship. Can AI be an inventor? If AI is used, am I an inventor? Where is the distinction between myself and the AI inventorship and all that stuff? So to start out, what we need to do is what is an inventor? So there have been multiple cases. There are multiple statutes and regulations and case law that defines what an inventor is. This case from 1994, Boise versus Benedict, sets out the initial definition of inventorship is in order the inventor must form a definite and permanent idea and of the complete and operable invention. So again, that is saying that an inventor has to form an idea. So right there, we're kind of getting into maybe it needs to be a human. Then we can start looking at some of the actual regulations themselves and the statutes. So these are 35 USC 100. The term inventor means the individual or joint of or if a joint invention, the individuals collectively who invented or discovered the subject. So individuals again, there is starting to again hint towards that the inventor needs to be a human being. 35 USC 115 says no third declaration under subsection A shall contain statements that such an individual believes himself or herself to be the original inventor or original joint inventor. Again, they're hinting that the inventor most likely needs to be human. And then we kind of get into 2012 in the Muhammad versus Palestinian Authority. This is where the Supreme Court rules that yes, an individual ordinarily means a human being. And that was the ruling that said that yes, an inventor is a human and must be a human. And they cite the reasoning that the court gave for that. One of the main ones was they cited the Dictionary Act. And then it says that the word person includes corporations, companies, associations, firms, partnerships, societies, joint stock companies, as well as individuals. So again, under the law, a human inventor must be a human. So that begs the question that I'm sure all of you came in here with is, are AI inventions patentable? So right at the top, I will just say, yes, they are. And we'll get into the caveats and kind of distinctions that we need to go through to do that. So the USPTO has issued guidelines on artificial intelligence and inventorship. There's the link there at the top for you if you want to go ahead and click on that, and you can read the registration, the guidance yourself. But essentially what it boils down to is what qualifies a human needs to provide a significant contribution to the invention itself in order to be considered an inventor. So that makes the standard as significant contribution. So what is that? What qualifies as a significant contribution? Well, essentially, the USPTO kind of deferred to existing law. They just went through the PANU factors, which were already kind of an existing framework for determining inventorship already, and they just kind of retrofitted AI into that. So what are the PANU factors? One, the person must contribute in some significant manner to the conception or reduction to practice of the invention. So recognition and appreciation of the inventions, simply put, means conception does not occur when there is only an unrecognized or accidental creation. The second factor is that the person must make a contribution to the claimed invention that is not insignificant in quality when that contribution is measured against the dimension of the full invention. And then the third factor is the person must do more than merely explain to the real inventors well-known concepts of the current state of the art. So essentially, you can't come in and just give a generalized background at the beginning of a meeting, and then the other people in that meeting come up with a new idea, and then you get to call yourself an inventor. That would not fly under the PANU factors. So what did the USPTO set forth in regarding AI with those factors? So construction of a prompt to elicit a particular solution from the AI system may qualify as a significant contribution. So for those of you who are familiar with the prompts can be very specific. If you are going in and you know a specific problem and you know a solution that you kind of want to get to, and you put in enough data and you frame that prompt in the right way, that may get you across that threshold of a significant contribution according to the PTO. The manipulation of an AI system's output. So if you put in a prompt into the AI system, it comes out with an output. If you do have to do an experimentation, to see if it actually works. Because again, one of the problems with AI that we'll get into in a little bit are hallucinations. Not everything the AI models tell you is true. So if there's experimentation at the end of it to that output, that might bring you across the threshold of a significant contribution. If you take that output and then you apply a process to it, if you're using that output in a further process beyond just the output or the outcome of your model, that may also bring you into the significant contribution. And then another way to get to the significant contribution is actually building the model yourself. So if you're designing, building, and training the AI system to address a particular problem that you or your corporation or anybody has, and you are the one who is putting the data, collecting the data, training, organizing the data, or just ingesting all the data, et cetera, and then fine tuning those models, that is enough to get you into the significant contribution threshold as well. So what does not qualify as a significant contribution in that sense? It would be merely recognizing a problem and then presenting that problem to the AI system. So just asking the AI system to solve a problem for you with you having no idea what the solution is going to be, no idea how to get there whatsoever, just coming up with a problem itself is not enough. So that is not going to get you across that threshold. So again, the construction of a prompt can be kind of key in here. For some of you who are more advanced in the AI technology, we have what's called retrieval augmented generation of prompts. So that's when you take like a ChatGPT on the shelf or on the market AI model that's already trained, but what you're doing, what you do is you frame the problem and then you also incorporate a whole bunch of other data into your prompt in order to get a very specific tailored response from that model itself, data that it most likely does not have. So it essentially tailors the response to what you have in mind. So that is what that we're talking about when we're saying you can't just merely recognize a problem and then ask it a question versus actually asking a specific tailored prompt and putting in that data. So reducing inventions to practice alone is not a significant contribution that rises to the level of inventorship. That's not new to AI. So a natural person who merely recognizes and appreciates the output of an AI system as an invention, particularly when the properties and utility of the output are apparent to those with ordinary skill, is not necessarily an inventor. So again, just kind of realizing, oh, the invention that the output of that model they gave me is not on the market. It's new, it's novel, but you just seeing that itself, you didn't do anything to get there, does not cross the threshold of significant contribution. And then also one of the big things is maintaining intellectual domination over the AI system does not, without more, make a person an inventor. So essentially, you can think of this in terms of like the ChatGPT, I would say, as an example. Microsoft or OpenAI, as the overall owner of that system, is not going to be an inventor in everything that that system comes up with. So they are maintaining intellectual domination over it, meaning they are in control of the servers, they are in control of, they've generated the initial algorithm, all that kind of stuff, but they are not going to be an inventor for everything that that model outputs for you. So that, again, intellectual domination does not cross that threshold. So now I'll turn it over to Ikenna, who will kind of talk about AI and subject matter eligibility.
Thank you, Sean. So yeah, as Sean explained, AI technologies, they bring new challenges to traditional patent systems. Some of these challenges include inventorship, patentability, AI protection, and ethical considerations. So as Sean explained, although AI itself can't be named as an inventor because it's not a human on a US application, the invention of an AI system itself is patentable if it does meet patentability requirements. Some of those requirements are patentable subject matter, utility, novelty, and non-obviousness and enablement. So of course, if the AI is directed to patentable subject matter itself, a patent can be acquired. Some of those areas include machines. That could be physical devices or systems that are patentable subject matter. The AI system itself could be directed to a process or methods that can include actions or steps that result in a specific or practical outcome. Of course, if the AI platform is directed toward compositions of matter, creating chemical compounds or substances, such as pharmaceuticals, materials, biotechnology, related inventions, or articles of manufacture. Those are ways that you can patent AI systems. Now, of course, moving on to the next slide, Sean. We have some factors here to consider when using AI. Of course, each company should consider these. An important factor to consider is the public disclosure that is caused by AI. Some concerns with public disclosure of AI involves ethical privacy breaches and societal challenges. So of course, it's important for companies to weigh the benefits and risks of disclosure considering how it could affect their competitive position or their compliance with laws and the broader impact on society. So some solutions that companies could implement are proper safeguards that regulate or detect public disclosures of AI technologies. You can move on to the next slide, Sean. All right, so to really understand the impact that AI has on pharmaceutical companies, it's important to understand the role of a pharmaceutical patent. So pharmaceutical patents, you can stay on the previous slide, Sean. Pharmaceutical patents are really the backbone of pharmaceutical companies. Really, they allow drug developers to possess exclusive rights in their inventions for a limited period of time. Typically, that's 20 years from filing the patent. So this exclusivity drives innovation, and it's critically important to a pharmaceutical company's return on investment. A fundamentally important function of a pharmaceutical patent is the ability for the owner to exclude others from the market. That involves defending against patent infringement, preventing alternative versions of a drug, for example, from entering the market for a specified period of time. Patent infringement, of course, just to explain it, that occurs when someone makes, uses, sells, or offers for sale a patented invention without the owner's permission. Of course, there's been issues with AI breaching those policies, and the owner can actually bring legal action against an infringer. So as you can see, patents are extremely crucial to any business, specifically pharmaceutical companies. We can move on to the next slide. So next here, we just have a list of patents that are common to the pharmaceutical industry. You have product patent that gives patent rights over a tangible product that an inventor has created. These patents protect the chemical structure or genetic sequences of a drug. You have process patents. They protect certain process of creating or manufacturing a product. Product by process patents, for example, that protects a certain chemical or specific process that's used to manufacture a drug. Formulation patents, these patents, they protect the way a drug is formulated and administered. So for example, they may cover the dosage form, route of administration, or delivery system used in medications. Another area there, that's method of use patents, which protect the way a drug can be utilized to treat an illness or disease. So these patents provide exclusivity for the drugs used in treating certain illnesses. Next slide, Sean, please. So just highlighting the importance of pharmaceutical patents. Again, it's very crucial to a company's return on investment, because developing a new drug, it can cost anywhere from about $314 million to about $2.8 billion just to develop a new drug. Again, that's important for the company's return on investment for the span of 20 years of exclusivity. We can move on to the next slide, Sean. All right, now that we understand the role of a pharmaceutical patent, let's take a look at how pharmaceutical companies actually use AI in their business. So AI can be used to accelerate drug discovery. So AI can significantly speed up the drug discovery process, which is critical for pharmaceutical companies to bring a new patented drug to the market. So for example, through machine learning and data analytics, AI has the ability to analyze large data sets. They can process massive amounts of data from clinical trials, scientific literature, genomic studies to identify potential drug candidates more quickly than the traditional methods that were used previously. AI can be implemented to identify new targets for drug development that may have been overlooked by a human researcher. Now, this enables companies to create innovative treatments that they can seek patents for. Another one is that companies can use AI for predictive analytics. So AI-powered predictive analytics can help predict how drugs will interact in a patient's body. Another way you can use predictive analytics is it can identify emerging trends and gaps in the pharmaceutical market. Now, that allows pharmaceutical companies to focus on developing innovative drugs for formulations that are likely to be successful and patentable. So, for example, AI can help address emerging diseases and treatments. It can do this by analyzing trends in disease prevalence, patient demographics, for example, and scientific research. AI has the ability to predict which therapeutic areas are likely to experience growth, and suggesting areas where new patents could be filed, which is extremely beneficial to pharmaceutical companies, of course, to stay ahead of the game. Now, AI, they can also assist with addressing patient needs in unmet markets. So AI can analyze data from clinical trials, patient records, and the global health data to predict unmet medical needs. They can enable pharmaceutical companies to target new drug candidates that can be brought to the market. Next slide, Sean. All right, so this slide breaks down the benefits that AI provides to pharmaceutical companies. So more examples is that AI can predict the behavior of molecules. They can help design compounds with desirable properties, such as higher efficacy, selecting drugs that have fewer side effects or simply just better bioavailability. Another important role that AI plays is that it can predict the commercial success of a drug. This helps pharmaceutical companies make informed decisions about which drugs are worth pursuing in the first place. So by analyzing factors such as clinical trials, again, it gives companies valuable insights on which candidates are likely to yield the most return on their investment. Next slide, Sean. Of course, AI does present challenges to the pharmaceutical industry. We've touched base on some of these regarding inventorship, but AI-generated inventions, they've spurred disagreement basically among patent offices all across the world as to who or what qualifies as an inventor in patent applications. Now, really, the issue is whether an AI platform that assists in creating an invention, should that be named as an inventor? For example, as it relates to pharmaceutical companies, an AI-powered system, it can be deployed pharmaceutical to identify molecular compounds in the discovery of a new drug. Now, it can do so without much human involvement. Now, the question is, does such AI assistance rise to the level of inventorship? And the answer is no, not in the United States, at least. That's according to the United States Court of Appeal to the Federal Circuit. Of course, that decision was handed down in the famous case Thaler versus Vidal. Next slide, Sean. So again, although AI itself can't be named as an inventor on the U.S. Patent application, the AI system itself can be patentable if it meets patentability requirements. Now, those requirements, again, that's patentable subject matter, utility, novelty, non-obviousness, and enablement. If it meets those requirements, of course, go ahead and try to obtain a patent. Now, during the patent examination process in the United States, patent claims that are directed towards AI-based inventions are typically treated the same as other computer-based inventions presently being examined at the USPTO. However, it's important that prosecutors and patent attorneys must ensure that the AI inventions fall within statutory category of patentable subject matter, and it meets the two-part Alice Mayo test to avoid patent eligibility rejections under examination. So generally, the likelihood, and I'll pause for a second here, we have our second poll. Give everyone a second to go ahead and answer. All right. So generally the likelihood of obtaining a patent on an AI invention increases when, for example, the patent claims actually capture a technological improvement that is exerted by the AI algorithm of the machine, as opposed to the eligibility of AI inventions it diminishes where the patent claims just merely recite characterizations of human activity or mental processes without showing any enhancement to the existing technology. So with that being said, I'll go ahead and pass things off to my colleague, Sean. He'll wrap things up for us.
All right. Yeah, and then I just kind of want to add a little bit onto the subject matter eligibility, just in terms of the actual computer-based invention part of it. Like Akena was saying, just reciting the human-based activities of the model, like saying training, inputting data, training the model, inputting data, and just receiving an output from that model is not enough. You're going to want to make sure in the disclosure, you've disclosed the problem that you want to have solved. And then you want to describe how the model is solving that. So you want to explain what data you're ingesting into there. You want to explain what you expect the model to do, how it's being trained, how it's learning. You want to explain what you're doing to the output from that model. And those things need to be captured within the claim language itself in order to get over that 101 threshold in terms of computer-based inventions and eligibility. So again, just reciting the words, inputting data, getting an output from an AI model is not going to be enough. You need to do a lot more, especially focusing on the problem that you want solved and how you're going to get it. So then that said, moving on, we'll go over the interplay of AI and copyrights. So again, just set off the base level here, copyright basics, 17 U.S.C. 102. Copyright protection exists in original works of authorship, fixed in any tangible medium of expression, et cetera. So the three key elements, as we know, of copyright is originality, authorship, and fixation. And obviously, AI kind of has a huge implication in all of those. So moving on. The U.S. Copyright Office has issued probably the most comprehensive amount of guidance between the USPTO. And so there's a link to the Copyrights AI page where you can go into and you can see the guidance that they have, and you can also see the decisions that have been kind of the more foundational decisions that the Copyright Office has made. So at a basic level, what I will say right off the bat is that it is well established that copyright can protect only material that is the product of human creativity. So again, an AI generated material is not going to be copyright protectable. So if you just ask an AI model to write you an article, the article that it outputs, and without you doing anything to that output, is not going to be copyrightable. Same thing with you just ask it to generate an image, et cetera, like that. And also, when you go and then you try and apply for copyright registration at the Copyright Office, if you have used AI in the generation of that material, you must disclose what parts of that material were you used AI to be generated. And you must disclaim that portion of the material that you're submitting. And we'll get into a little bit how that looks like in the next slide. But the Copyright Office sets out this basic formulaic test. Basically, it's asking, is the work basically one of human authorship where the computer was merely being an assisting instrument, or are the traditional elements of authorship in the work, literary, artistic, musical, elements of selection and arrangement, et cetera, were they actually conceived and executed by the machine and not by a human being? So with that said, we'll go into some examples of where there would be no human authorship under that test. So if a work's traditional elements of authorship were produced by a machine, the work lacks human authorship. So again, if you're just asking a model to write you an article on subject X and you go ahead and just try and register that, that cannot be registered as a copyright. Again, the AI created everything and you put no input into it whatsoever. When an AI technology receives solely a prompt from a human and produces complex written visual works, that is not going to be the product of the human user. Just putting a prompt into an AI model is not going to be enough. There is an example on the Copyright Office's page where an author put in 624 iterative prompts to keep refining the output of the model itself, and that still was not enough to overcome the threshold for human authorship in terms of copyrights. Again, they say that these prompts function more like instructions to a commissioned artist. They identify what the prompter wishes to have depicted, but the machine determines how to use those instructions and actually implement in its output. So again, no matter how many prompts, no how many iteration of refinement prompts that you put into a model, the actual output, unless you actually change it in some significant way, is not going to be registerable. And then when an AI technology determines the expressive elements of its output, the generated material is not going to be the product of human authorship. So that comes down, well, when will human authorship be there? So a human may select or arrange AI generated materials in a sufficiently creative way that the resulting work itself will be an original work of authorship. So in one example, what we had was a person tried to register a comic book with the Copyright Office. That person was originally granted a copyright, and then through investigation online, it came to the Copyright Office's attention that all the images in that comic book were AI generated. And so the Copyright Office took back that copyright registration, and then they went to the board over arguments over all of that. And ultimately, what came down to the decision from the board was that the actual images themselves in that comic book, they were all AI generated with little to almost no changes by the author herself. Those images themselves were not copyrightable. Or they could not be registered as a copyright to satisfy Stevens' verb terms and things like that. It applies to copyrights and patents too, technically. So what she could get a copyright for was the actual combination of the arrangement, the particular arrangement of those images with the text that she did generate for that work. So again, the individual images themselves were not copyrightable, but the work itself as a whole was. An artist may modify the material originally generated by the AI to such a degree that the modifications will meet the standard for copyright protection. Again, in this particular instance, you will need to still disclaim all of the portions of that were generated by AI. You will only be able to get copyright registration on the portions that you yourself modified or significantly changed. So there are several examples of this, but since we're running short on time, again, that page with the Copyrights AI page has all the case law and board decisions, foundational board decisions that cover that. So kind of the factors to consider when using AI when you're thinking about copyrights is, again, authorship. Was AI used? If so, do I need to disclaim a portion of this? Did I do enough modification to this to be able to get copyright protection on certain portions of it? Ownership. So no copyrights, they cannot get a copyright for AI generated material. So for instance, everything that's being generated by ChatGPT is not owned by OpenAI. They do not get to get a copyright on that material. So ownership comes into play. And then again, is there enough human authorship, human modification to the output of those AI models? I mentioned this briefly when we talked about patents, hallucinations. I do this as a warning to people who use ChatGPT and all those other large language models to generate articles, especially scholarly articles or legal opinions, et cetera, all that stuff. Is remember the AI model is just ingesting raw data, a lot of data, and it's just outputting what it has determined to be a relationship amongst that data. What it outputs is not necessarily true. We've all heard of the case of the case law where I believe it was in Texas where a lawyer asked the ChatGPT to generate a brief for them, and it just made up case law. And he submitted that brief and was caught. So again, that would be a type of hallucination. The made-up case law that the AI model generated, it would be a hallucination. So again, hallucination is just AI perceives patterns or objects that are non-existent or imperceptible to human observers, creating nonsensical or inaccurate outputs. So we must be aware that that happens when we use these models. And the last kind of thing to consider is plagiarism and infringement. Who's responsible? There are a bunch of lawsuits. None of them have been decided. There's been I cannot give you a definitive answer on all of this, but who's going to be responsible for potential copyright infringement? Right now, the New York Times and a bunch of other people, cases have been combined into one. And the New York Times is alleging infringement, that OpenAI has infringed their copyrights by just merely ingesting and training the ChatGPT algorithm on their material. So again, will they be held responsible? Who knows? Or is it fair use? Like OpenAI and Microsoft are arguing. We don't have an answer on that quite yet. And then again, will the end user be responsible for plagiarism? So I just, again, check what the AI model outputs, proofread it, and change it. I know I'm just rushing through because we are at the end of our hour here. So I apologize. I know there are some questions in the Q&A. I will try answer those through email, or one of us will try and get back to you and answer those questions that way. And if anybody does have more questions for us, please, our contact info is here. You can email or contact any of us, and we would be happy to get back to you. So again, thank you all so much for joining us this morning. Have a great day.